to Know Your Rights, a show that seeks to focus on constitutional matters as well as the Bill of Rights. My name is Brighton. This is Center for Innovation and Technology. We're on the show. I'm joined by Dumisani and Dube from Mathonsi. Say, how are you?
I'm fine.
I'm great. So let's talk about the issue of traditional courts in Zimbabwe. What role do they play?
No, traditional courts are part of Zimbabwe judicial, where chiefs and governments arbitrate over disputes and other issues in their localities using their traditional law, customary practices, which date back to centuries of generations. And they also recognize in terms of the constitution as part of lawmaking. They play an active component in our judicial system because they have easy access to the courts, which is villagers or members of the local community. There's less procedural requirements which hinder access to the courts. So it makes it easy for people to access and pursue justice on a day-to-day basis using their historical customary practices, cultural rights, and precedents.
Right, so when looking at the traditional courts, what are some of the cases that the chief can preside over on a day-to-day basis at the end of the court?
You need to know that traditional courts are unique to specific geographical locations and cultural practices. A traditional court being superintended by the village chief is different to one which will be superintended by another chief due to a number of cultural practices which are peculiar to each specific community or locality. They can actually literally do anything from adultery, witchcraft, arson, claim of lands, in as much as they are regulated by their traditional practices. In fact, in terms of the law, there's no written limitations to the rights of a chief. It's subject to cultural heritage, history, and practices.
Right, so in an event that the chief presides over a court case, traditional court case, and then some of the victims or some of the people accused in the case feel like this ruling is not proper for us, can they go and approach other high courts, so-called courts in
yes.
the land?
Well, the conduct of the chief is also represented by the Traditional Leaders Act. There's also Customary Law Courts Act, which regulates the conduct of the chief, and also the Constitution of Zimbabwe. Basically, natural justice principles rules are followed, where the chief or the arbitrator has an opportunity to hear both parties' evidence is also led. Record of proceedings is also recorded. Then, for checks and balances, that decision is then confirmed or registered with the magistrate court, because that's the next hierarchy. Then, from that end, the next court of appeal or review is the High Court. Then, the Supreme Court and the Constitutional Court.
Right. Now, talking about the community rights, the cultural rights, customary rights in any village, there's the point where the chief presides over property of the village, with communal property. The chief has the power, supreme power over the soil, over the land, over anything in the community. Can the chief do anything, like as a child, or as a punishment to any victim or accused? Like taking away their land or taking away anything of the land?
Chiefs and traditional leaders are custodians of culture. They are the owners of the land and common property in that locality. This is a practice which dates back to centuries of years. Even you remember that even back then, kings and queens also played the same role. They also have an interface between society and God, or society and the spirit mediums, and so there is a range of responsibilities and roles which chiefs have, and in that role, it's the chieftaincy is an institution. It's not an individual, and if customary practices which date back to centuries as a result of precedents. However, they're also regulated by the law. That is the codified law or written law, which has been written and passed by the legislature for checks and balances.
So when the chief passes a judgment, for instance, a community level, so and so is found guilty, this is the community level, the chief passes the judgment, and then someone feels this judgment is not proper for me, then they appeal to the court. The court finds a different judgment than the one given by the chief. Now, let's talk about the respect now of the chief from that village. The chief gave us the wrong judgment, the court gave us the different judgment. That's what the level of respect from the subjects to the chief.
All judicial decisions are subject to reviews. If you're not happy in terms of natural justice principles, the protection of the law, in terms of the constitution, you can go to a higher court to act as an arbiter. Remember, chiefs are not trained judicial officers. Even judicial officers such as magistrates, judges, depending on each particular case, they come with different decisions. And there's always the right to appeal. Every other day, High Court decisions are taken on review, are taken on appeal to the Supreme Court. Even Supreme Court decisions, constitutional matters are taken to the Constitutional Court. So the law is not mathematics. There are a lot of things which influence or determine the decisions of judicial officers. They call it the science of the jurisprudence, the world outlook. But like I've said, the practice of law is not arithmetic. It's not 1 + 1 is 2. We have changing values. Customs change as communities or societies modernize.
So now let's focus on the Chief Ndiweni's case, where the chief passed the sentence to Umbele, and we appealed to the court because now sentenced Chief Ndiweni to 18 months in jail. What's your take on that?
I wanted to clarify one thing. In the Bele case, the institution of the chieftains playing its role as a judicial functioner was approached through the village head, and determinations, court hearings were made. Determinations were made after evidence had been, after the due process, which was being led by a traditional leader in that particular area. That decision was never appealed. It was never reviewed. It still stands. It's a valid decision of a traditional court, which still stands. It has been enforced, and enforcement did not be challenged or reviewed.
This case has been going over for over 2 years now. According to the video circulating of Chief Ndiweni saying this case has been going over for 2 years now. What has been some of the things stopping the case from being finalized?
Without going to the merits of the case, after Chief Ndiweni had made a determination in his role as a traditional leader, as provided by the Customary Law, the Courts Act, the Traditional Leaders Act, and the Constitution of Zimbabwe, attempts were made to enforce that court order. In fact, what happened is Mbele's wife was then taken back to a chief by Chief Ndiweni as per customary law practices of Ndebele culture. She was left with the people. Then operating for agents went to that woman. They went and did a rally in front of the Ndiweni's homestead. They reinstated, told her to go back to matrimonial law. They made a report to be made, which report was disowned even by the court. It's a matter of public record. Mbele's son and his siblings are also charged in this particular matter for enforcing a lawful and valid order of a traditional court. So when the report was made initially, police officers didn't want to investigate because it was not their role to investigate that matter. But also need to understand that at the time Mr. Prof was still the Minister of Home Affairs. With too much power, instructions were made to the Prof at the time. We then influenced the officer in charge to round up villagers and open the gate. So basically, that's what happens. What also stalled the case was numerous attempts were made to subpoena Mr. Pope to come to court. Prosecution was afraid to even call him to come to court. Police were even not able to subpoena him to come to court. Up to a stage where the court had to make a determination for him to be compelled to come to court. So those are the issues which delayed the trial of Nhlanhlayamangwe in these 23 subjects.
Right. So bringing an interesting point there of politicians now meddling into the affairs of traditional codes and also trying to be above the law. Let's talk about the issue of politicians now. Can they meddle or interfere in terms of the traditional codes to the chief can say pass the judgment or interfere with the victims or accused in any case of traditional matter?
Oftentimes, there's also that friction between traditional leaders and politicians of particular areas because of the fight for influence. Remember, we were approaching elections during that time. So there's always that fight between traditional leaders and politicians who feel at times traditional leaders have more power than politicians. They might even challenge them for office. So those are the issues which are there.
But now, is there a violation of the Constitutional Act, Traditional Act, or Customary Act, which now politicians or anyone, a minister, anyone in power can now interfere? Is that a violation of the Customary Act or Traditional Act?
Obviously, there's tension between traditional customs. Remember, after time, traditional law is not codified, it's not written law. It passes from generation to generation. Then you have law, which is legislated by parliamentarians, which is codified or written. But even our constitution, that is the supreme law of the country, recognizes traditional law, traditional practices and customs.
However, in this matter, the chief passes a judgment and says the person is found guilty of this and ABC. Now the minister, because of power that they have, they come and say no, I'm not guilty because of the power that I have as a minister.
Obviously, remember, law is also a reflection of the ruling elite in each particular society. Because law is crafted by parliamentarians and people of influence in the society to manage the rest of the society. So basically here in my view, it was an abuse of legal processes by political actors to settle their scores, which also even led to an unjust and fair outcome.
Right. So now let's talk about the sentencing of the chief. 18 months in jail. Was it fair for the chief? Can the chief be sentenced for 18 months?
Before a chief, in terms of practices, before even the chief is arrested or arraigned to court, there's a practice where the AG's office issues a certificate or authorizes its officers till the matter prosecuted. I think it's an administrative mechanism. Remember, when the chief makes that decision, he doesn't make it in his individual capacity. He's simply a judicial officer who is making that determination. And if you're happy, or if you're not happy, you can review him. You can review if there are procedural irregularities. We can actually take it on appeal to a higher court. So it's rare for judicial officers to be prosecuted for decisions which they've made in court, especially in the absence of criminal abuse of office. Yes, chiefs have unfettered powers in terms of customary practices. There's been no law or determination by any superior court which limits the powers of the chief, because it's subject to the culture and tradition and customary rights or practices of a particular group of people who agree and abide by those decisions. Remember, even in this matter, Fetimbele is the one who approached the chief's court to report a case. His children also approached that were there to support him, even his relatives were also part of the convicted persons, which also shows the actual interface between customary law and general law practices. But I submit that a gross injustice was made in terms of sentence. It was absurd. Precedence has been said that if someone is being convicted or sentenced to a sentence of less than 24 months, community service should be granted. There are numerous cases to that effect. Even the way chief is discriminated from the rest of his co-accused, it shows that there's clearly a pattern which is playing politics to settle scores.
Right. There have been also speculating over the past few days saying that the chief has been moved to Ndura, prison to our prison. How far true are those statements? And is it proper for them to move from the current prison to other prisons in Ndura and all?
Yeah, I think that's an administrative issue for, I think, prisons or correctional services. But what I can confirm is that it's still at current prisons. I'm not sure that attempts were made to move him from current prison to our.
So I saw a picture of King Nhlanhlayamangwe Command who came to visit the chief, and then they denied him access to see the chief, saying he doesn't have papers to visit the chief. Was that proper for the prison officers to deny him to see?
I think it's unfair for prison officers or anyone to stop any citizen.
Do you need to have a paper to visit someone in jail?
No, what you need is just identification. You can be allowed. It's once you identification in the form of national passport or national identification, you can be allowed to go in and out of prison to visit anyone.
So now let me bring the issue of communal land, communal property. Suppose this is my house, I buy this house, I put a fence on the house, and then we're in a village, I put a fence on the house, and then I commit a crime. And then the chief says the fence must be removed, but it's my property. Someone says it's my property, I can argue and say it's my property. But now the chief can say it's owned by the community. Does the chief have a right to remove the fence of my house?
All rural land is state land. If it all land is state land, all rural land is state land. That's why rural land is no value. It cannot be attached. And the chiefs are the custodian of the land. They have the power to allocate land. They have the power to punish. These are practices which have been dating back to centuries. So the chiefs have powers to regulate and enforce law in the area. They have the power to even take your land because all land is state land.
So then just move from this issue of the chief and focus on some of the gross human rights violations that have been happening in Zimbabwe over the past few weeks. We have seen some members of the MTC being abducted. We have seen comedians being abducted. So about the issue of comedians in Zimbabwe, is there like their rights, are they free to say anything?
Artists have an artistic freedom of expression, but all dictators, in the course of humankind, deal heavily with artists. Because some of the people can freely express the views or sentiments of a particular group at that particular time. Activists have been killed in many jurisdictions during dictatorships, which don't respect rule of law and constitutional rights.
So, but now, can you say there's freedom of expression in Zimbabwe? Seeing now activists and artists being abducted, can you say there's freedom of expression in Zimbabwe? Is there democracy in Zimbabwe?
In terms of law, yes, on paper, the Constitution calls for freedom of expression. It calls for democratic rights. But what has been happening is that we've seen the state dealing heavily with its citizens, which I think is unfair. It's a breach of domestic and international law. And unfortunately, we've gone back to the dark days of Robert Mugabe, where citizens live in fear, activists are being threatened, judicial officers are also being threatened. There are now gross human rights violations. There's air of fear in the air. Opposing activists are also being assaulted. It's said, if you look at what happened in Harare last week, no one would have expected that this republic or this administration, which we so much celebrated and we thought was going to usher hope, will act in such a manner.
So speaking of the demonstrations in Harare, now the issue of the MTC, they said they applied to the police for clearance to demonstrate. It's part of the constitution for them to right to petition and demonstrate. But now, can the police have the right to ban any demonstration?
In terms of jurisprudence, in a just law is no law at all. It is no respect to be. You should not even respect any just law. It's not there. If compared to civil rights movements, even in America, when people like Madam Rosa Parker were demonstrating against blacks using public transport, even in South Africa, they didn't respect those laws. And unjust laws don't need to be respected. You don't even need to comply with unjust laws.
So as journalists, on Monday we were at court. There was demonstration in Bulawayo. So at court now the police were everywhere in the streets of Bulawayo, carrying guns, carrying those shields. So now it's instilling fear to the public. As a journalist, I was asked, why are you coming to the court? So but I was wearing my press card, my press jacket. Police were like asking me questions. Is that okay for the police, people who are supposed to protect the public now, to question the public or to instill fear to the public?
It's not okay. Like I've said, there's been too much securitization of the state, which is taking this country back to the dark days of property crime. It's unfortunate, but that's what is happening. It's unfair. I was also being harassed on Monday when I tried to get into court. So imagine if the audacity to harass a lawyer, an officer of the court, the journalists who are supposed to be covering court processes. What about the ordinary men on the streets? So it's sad, dark days. It's unfortunate, these are the times we live. And certainly we need to do something about it.
So in terms of the chief's matter, where to from here? Are you going to appeal?
No, we filed an appeal on Monday. We've also filed an application for bail to be held pending appeal. Because what happened is that all the judicial officers in the law courts decided to recuse themselves from the matter for security reasons. So we're just waiting for an appeal to be held. I'm sure before the end of the year we might actually have a date on which we're going to go into court and have the matter argued.
So anything that you want to say in terms of the human rights violation that happened in Zimbabwe, particularly the Monday one, the Monday 19th, what were your experience in terms of Nhlanhlayamangwe?
I'm just calling upon the powers to exercise restraint, respect the constitution, respect the international law. Because one day all of us are going to account. We will not account here on it, but certainly will account even on our maker. And I think this has been a step. We've regressed back to Robert Mugabe's days, which is not good for our country. We're opening the country to the international community. Let's respect the rule of law. Basically, I think that's our mandate. Elected officials who are sworn to public office and who are sworn to defend the constitution and the law, I think they need to respect their oath of office.
Thank you so much, Dumisani, for your time. Thank you for joining us. And thank you for sharing information about the constitution of Zimbabwe and what it means to elect these things.
No, thanks, and you're welcome. Have a good day.
Right, there you have it. It says, one day you're going to account, not on earth, but you're going to account one day to the maker. And the rule of law must be respected in Zimbabwe. This has been Know Your Right. I was joined by Dumisani Dube from Mathonsi. We're talking about the constitutional matters as well as referring to the case of Chief Nhlanhlayamangwe Ndiweni. Till next time, my name is Brighton. Do follow us on Twitter at SizeW. Do follow me on Twitter at Reflector. This is Know Your Right. #Asaki.